Welcome to Crestview Community TV's Court TV. I'm Ryan Hardy, your Crestview Community TV legal analyst, and today we're watching the miscellaneous court date / VOP court date. You're going to see, by VOP we mean violation of probation, and you're going to see a lot of people this morning who are, a lot of them are going to be incarcerated because they violated their probation. When you violate your probation, you're not entitled to a bond. Doesn't mean you can't get one. It means it's harder to get one. On a new law violation, most people are entitled to a bond, absent some major circumstances. When you violate that probation, though, you're not entitled to a bond, but you can get one. But that leads this court date to having a lot more inmates. Now, when you're called to the podium, a couple things you can do. You can enter a plea to your VOP and say, yes, I did it, I violated my probation, and you can get sentenced. You can ask for a continuance. Let's set this down the road, maybe try to work out some details, maybe try to work out a deal. Or you can ask for a contested VOP hearing, which will be set at a later date in one of the afternoons of this miscellaneous date. Now, VOP hearings are very hard to win. It's a different standard of proof. We don't see a lot of them because it's rather easy for the state to prove if you violated your probation or not. So you're not going to see a lot of contested VOP hearings. Now, in addition to the violations of probation in the mornings, you're going to see some other smaller, shorter hearings, things like bond hearings, or things that don't take a lot of time, normally 15 minutes or less on these morning hearings. Anything longer than that is going to be set to the afternoon.
You have the attorney list? Sorry we're running a little late. We had a Zoom hearing, a specialized hearing that we had to handle before we started with our regular miscellaneous docket. Okay. Mr. Patel.
Good morning, Judge.
Good morning.
Jay Patel on behalf of Joel Anthony Jopling, 22 CF.
Hold on just a second. Hold on. Let me get myself organized here. Okay, go ahead.
Good morning, Judge. Jay Patel on behalf of Joel Anthony Jopling, 22 CF 2303. Mr. Jopling's before the court on a motion to early terminate pretrial intervention supervision. I do not believe that there's an objection to our motion for early termination.
State.
That's correct, Judge. The state has reviewed the motion, has attempted to contact the victim. We have been unsuccessful, but we do not have any objections to the motion at this time.
Very good.
At this time, Judge, based upon the state stipulation, I'd ask, with the court agreeing that the supervision shall be terminated early, that we'd ask to withdraw his plea and move for a dismissal.
State.
The state would have no objection. My understanding was that that was the terms of the original agreement.
Very good. Based upon stipulation of the state, the court will grant the request of the defense and dismiss.
Judge, would you like me to send an order?
I would appreciate it.
Thank you, Judge. I have nothing further. May I be excused?
Yes, ma'am. Thank you. Okay, we'll do it. Mr. Highsmith. Okay, good morning, Mr. Highsmith.
Good morning, sir.
This is, with the state announced, this is one of the violations. It's violation of probation 19 CF 3006. So, Mr. Highsmith, you do have a right under this new violation. This is more or less like an arraignment. This is your first time up.
Yes, sir.
You do have a right to have an attorney, unless, have you had any conversation? I don't know.
We have, Your Honor. My offer today is an adjudication, revoke and terminate, court costs, and send all outstanding requirements to collections. My understanding from Mr. Highsmith, he'll have to speak for himself, is that he wanted to accept that today.
Okay.
Yes, sir.
That is correct?
Yes, sir.
Okay. Very good. So what are the terms? Again, let's make sure and put them on the record.
The terms are, he'll be adjudicated for the VOP,
Okay.
revoke and terminate probation. He'll have to pay court costs in the amount of $100, which is the VOP fee. And all outstanding restitution and court costs and fines, all will be going to a civil lien.
Okay. Is there restitution outstanding on this?
There was none ordered.
I don't believe there is, but that's just how I write.
Mr. Medina?
Yeah, just as an officer of the court, I wanted to have the court aware. I don't know whether this gentleman is already a convicted felon and whether this would be adjudicating him as a convicted felon for the first time. If so, he might want to be aware of that.
Thank you, Mr. Medina. He's already been adjudicated.
Thank you.
So that's a good point, Mr. Medina. Okay. And one, you might have wanted to talk with an attorney, but if it's already a prior adjudication, it doesn't affect that. So raise your right hand. Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
You believe this is in your best interest to enter this plea on the violation of probation? You can put your hand up.
Yes, sir.
At this point today,
Yes, sir.
and you haven't had a chance to talk to your attorney. You do have a right to have an attorney appointed if you wanted to talk with one before you do anything. Are you comfortable waiving that right and just going ahead with this?
Yes, sir.
Counsel?
Judge, I apologize. I just want to put something on the record real quick. Sir, we spoke before this, and you told me you had been adjudicated a felon, correct?
Yes, I'm convicted of it.
All right, thank you. I just want to get that on the
I
record.
mean,
Okay, that's an important factor. I mean,
I
that's
understand.
something that could have been negotiated, and the state doesn't, you know, it's fine, as long as everybody's, all we want to do,
Yeah,
my
gotcha.
purpose is to make sure you understand what you're doing. We're not
Yes.
trying to trick you.
I understand.
You know, get you to agree to this and resolve it, and then all of a sudden you didn't realize, well, I didn't realize this happened, so. But it looks like you got, it's pretty straightforward, revoke and terminate, probation will end, everything goes to collections.
Yes, sir.
Okay, very good, thank you very much.
Done?
Mr. LaPella. Question?
Do I need, can I get something saying that I've been terminated?
Does he get something in the order? Doesn't he get an order?
I think probation gets him the order, Judge.
Okay. So talk with probation right now, they'll kind of tell you what's gonna happen. He's downstairs. Okay, we'll pass over Mr. LaPella. Ms. Dudley?
Good morning, Your Honor. I have Angelique Johnson. And 15 CF 2330.
I don't have Angelique. Is that? under-
ENJOLI. Is that the first
He's
name
not,
spelled?
she is number one on the docket.
It's unique spelling, Your Honor.
Not on my docket. Sorry. Is that under one of the? Oh, it looks like people have a different one than I have. That's all right. We'll go slow and just write down, give me the name and the case number, and I can make sure and write it down.
Yes, sir. Angelique is ENJOLI.
Okay?
Johnson,
Johnson?
15 CF 2330.
And we're here on a, what?
Violation of probation, Your Honor.
Okay, very good. So where are we at?
We've already
Is this the
entered,
first time up?
yes,
for
it's
this?
arraignment.
Okay.
We've entered a denial. We'll just ask for the track with the new case on the December pretrial. The new case number is 23 CF 1991.
You have it.
And I think it's already set on December 11th.
Thank you. Okay, so our next up is October 11th. Okay. So we'll continue this till October 11th.
October 11th? Her new case is on December 11th, Your Honor. So you want to put them both on that day, or?
No, let's see. Why isn't the new case on the, why don't we do it in October? Is that too fast?
Well, I can look up the new case.
What's the new case?
It's 23 CF 1991, and it's scheduled for December 11th, I believe.
Say the case number again slower.
Yes, sir. 23 CF 1991.
Okay.
The state would be fine with the October date. We've already processed discovery.
I just don't know why it's in December
Yes, sir.
rather than October. We're trying to get them as fast, just more delay.
That's fine with us, Your Honor.
So we'll do it for October 11th.
Yes, sir.
Both of them will track together.
Yes, sir.
Okay, thank you.
Now, as for the new charge, I do not show the information in the case yet. That's why it's set out for December, but it just happened. So, but I can go ahead and just,
We can just leave it on October. The state said they've already,
because there's
at
a
least,
thing coming out October 12th.
Okay. Hopefully we can, we'll be able to bring them together and
yes,
get-
sir. All right, thank you.
Okay.
That's all I have, Your Honor.
That's good. I understand why. Thank you, Ms. Dudley. Mr. Noakes.
Judge, I've got Jeremy Sullivan, 2020 CF 698, 2020 CF 952, and 2020 CF 1545. Judge, the state and I have been discussing this case and waiting to get an official offer. We got an official offer on Friday. I went to the jail and talked to my client about it. There's some questions he has, that my client has. The state and I are going to go and look at the firearms that were taken, because our position is they were antique firearms, and that may very well change something, but in any event, we just need to set it off for another date.
Okay. So I've got it listed as a status. Is this the underlying, this isn't a VOP, it's the underlying cases?
Judge, he was in state prison for Santa Rosa cases, and we had him transported back just to, there was a failure to appear, but he was in jail in Santa Rosa County. So we had him transported back just so we could try to address these cases and get them resolved. They're brand new cases.
Okay. So we'll just continue them, and information been filed till October 11th, just tracking.
Well, Judge,
I'm sorry, go ahead.
my thoughts on this case are this, and I've already shared this with Mr. Nopes, but I think that these cases are rusty. I would like
Are
to-
what?
Rusty. They're old. I'm
They're
trying
old.
to push them. And specifically, I would like to tee up case number ending in 952 for trial this cycle. It is a Min-Man where the defendant admitted to possession of the firearms. I'd like to go ahead, and I'm just letting the court know, guide this towards trial this cycle on that one case. And in the meantime, I believe Mr. Nopes and I are going to go look at the firearms.
Well, I mean, just so you understand, from my perspective, I'm teeing them all up. You don't have to tell me, you don't have to give me any special, hey, we're teeing this one up. And unless something is going on that delays it, we're moving in that direction. So, but I think, just sharing it with opposing counsel is more important. But I'm ready to go. As a matter of fact, we need to get a few trials lined up, so. Anyway, we'll come back on a regular, next day on October 11th, pre-trial.
Okay.
We'll be in the regular cycle. Okay.
Thank you, Judge.
Thank you. Have a great day. I think that's all you got here, Mr. Bell.
That's it, Judge. Thank you.
Okay, have a good day. Ms. Reed?
Hi, good morning, Judge.
Good morning.
I
Could you
have-
announce your case? And because I've got two under him, and I'm not sure you're on both of them, but.
That's correct, Judge. I am on 23 CF 1329. That's on this morning's docket for change of plea. The second case number, Your Honor, is 23 CF 1894. That's on this afternoon's docket for arraignment. However, this plea agreement that we've reached is going to address both cases.
Okay.
May I approach with the plea agreement? Well, let me get my client to sign
Sure.
real quick. She's going to testify.
So have you made an appearance in 23 CF 1894?
No, Your Honor, I am just a friend of the court, and I'll do this as some pro bono on 1894.
Okay.
Okay. So if you just want to sign right there. Oh, you already did. Okay. All right. Okay, Your Honor, let me just, I'm hoping that the plea agreement did not get out of 1, 2, 3, 4. Great. May I approach?
You may.
Thank you.
Thank you. Would you please please announce the terms of the plea?
Yes, Your Honor, and I also have copies for the state and probation.
Thank you very much.
Absolutely. Okay, for the record, Your Honor, Cassie Reed appearing for Mr. Ariel Orlando Barrios in two case numbers, 23 CF 1329 and 23 CF 1894. The plea agreement reached between the defendant and the state is in 23 CF 1329. Counts 1, 2, and 4 of the information will be dismissed. Counts 3 and 5 will be pled as charged. The terms will be that Mr. Barrios will be adjudicated guilty. He will be placed on 1 year with state probation. Be assessed the standard fines and costs to include the cost of prosecution. To have no contact with Samantha Gaglione. Complete the batter's intervention program, abide by any injunctions, no firearms or drugs not prescribed during supervision, and submit to random UAs at least once per month during supervision. He would be withdrawing his previously entered plea of not guilty and entering a plea of no contest to that case. In 23 CF 1894, Your Honor, my client will be entering a plea of no contest. The terms of that agreement are counts 1 and 2 of the information will be dismissed. Count 3 will be pled to a lesser included offense of misdemeanor battery. The terms are that Mr. Berrios would be adjudicated guilty. He would be placed on 1 year with state probation, which is to run consecutive to the probation ordered in 23 CF 1329. All other sanctions ordered in 23 CF 1329 are to run concurrent. Mr. Berrios may apply for early termination at 1 year if all conditions are met.
Okay, just a technical question and then a clarification.
Yes.
When you have 2 consecutive terms of 1 year, how can you early terminate after 1 year if one of them doesn't even start until then?
That's a good
I
question.
understand what you're trying to do. I just want to make sure that this.
And that is a good question, Your Honor. I believe that if Mr. Berrios completes everything in that first year, we can, and then that second year starts, he can apply to early term once his second year kicks in, with the argument being he's completed all the terms.
Okay, is that correct?
That would be the halfway point, Your Honor, and I think that's statutory, that someone can apply anyways for early term and halfway.
Even when they're consecutive versus, okay, very good. One other thing.
Yes, Your Honor.
Just very small detail on your first, on both of the, the 1894, you're actually only pleading to 1 count, but in 1329, you're pleading to 2 counts.
Yes, Your Honor.
And you need to put on here that the probation is
Concurrent between the 2 counts.
Your Honor, while Ms. Reed is doing that, the state needs to put on record that the victim did file several drop charge forms. So the victim would have preferred that the state just dismissed all the charges. This is the middle ground to ensure her safety, ensure no contact order, but also ensure that, Mr. Berrios was getting a deal that he was able to take. And I do believe that this is in the victim's best interest, Your Honor. So this is why the state made this deal with the defendant.
very good.
2 and, I'm sorry, counts 4, counts 3 and 5, okay? Counts 3 and 5. Yeah, but it's still 2 years. Okay, thank you.
Thank you. Okay, Mr. Berrios, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, Your Honor.
Okay, so you heard your attorney state the terms of your plea agreement.
Yes, Your Honor.
Those same terms are contained in the written plea agreement, which I'm assuming you've signed, which you've signed. So my first question is, did you read this plea agreement closely?
Yes, sir.
And did you go over it in detail with your attorney, make sure you have all your legal questions answered regarding this plea agreement?
Correct, Your Honor.
Because there's a lot of details, even more than what she said about, one is that, acknowledging that you're waiving the right to go to a trial on all this, to contest all these cases.
Yes,
Okay,
sir.
that's a
I'm
valuable
satisfied.
legal right you're waiving in order to get a final resolution here today. Is that what you want to do?
Yes, Your
You
Honor.
believe that's in your best interest? You believe that's in your best interest?
I do believe that's in my best interest, Your Honor.
And importantly on this, I just want to point it out to you because it's going to come back and haunt you if you don't. Batter's intervention program is a lengthy program. It's been a part of 6 months. Don't wait for 6 months to start this thing. You'll be right up against your year-long if you don't complete this stuff, and they're going to be wanting to extend your probation and even violate you. Okay?
I understand.
So make sure that actually is during the first year of probation. So you need to get on that right away. That's the only thing. Focus on. So any other questions regarding this? You understand that standard. We don't have the
I think the misdemeanor cost in 1329 would be, is it 270? Wow, it's going back, it's locked in here somewhere.
Is that in the agreement?
I think it says standard court costs, Your Honor, for the misdemeanor, but it doesn't have the exact amount, which would be $270 cost.
I don't think it says standard court costs, but we just need to make sure to include that in there. Okay.
Yes, Your Honor.
Fees and costs are paid during the term of the probation, okay?
Yes, Your Honor.
Thank you very much. Do we have a score sheet?
It's to all
All
misdemeanors, Your
misdemeanors?
Honor.
Okay, very good.
And this should, with this plea agreement, Mr. Barrios should be eligible for release today.
Okay, very good. Thank you, Ms. Reed.
Absolutely.
Mr. LaPella?
And Judge, that's all I have. May I be excused?
You may. Thank you. Have a nice day.
You as well, Judge.
Good morning. I'm not on the docket this morning, Judge, but I have a hearing this afternoon, and I think we're going to cancel it because the state's going to send the case down to misdemeanor court. That's Andrew Ham.
Yes.
It's set for 2:30. We can go ahead and cancel it.
So the motion to suppress is being canceled. Who's on that for the
I am, Your Honor. That's correct. So I've worked well, first off, I reviewed the file and I determined that the defendant does not have the necessary prerequisites to make this DWLSR a felony. So we've done the paperwork internally to move it down to misdemeanor court, since I can't file information in this court and plead him to the misdemeanor.
Okay.
So we worked out a plea agreement for when it gets down there.
Okay. So this is case number 2023 CF 1619. So for today, I'm just canceling the hearing to allow you all to move the case down to county.
Correct.
Okay. Very good. Thank you.
Thank you, Your Honor.
Thank you.
All right, good day.
Yeah, let's go ahead and do those. So we have several defendants here today, that should be here, that are here without an attorney. You may have spoken with the state and about a plea deal, but for today, the purpose of today's hearing, most of these are new cases, new violations of probation. So if you're here without an attorney on a violation of probation, we're here to basically take a plea to admit or deny. But in order to protect your rights, you also have the right to have an attorney if you cannot afford one. And so if you don't have an attorney, I'm going to ask you to come forward. I'm going to ask you whether you want to have an attorney. I'll appoint you an attorney and we'll enter a denial here today. So it'll allow us to allow you to speak with your attorney before taking any action, unless you did want to take a plea. So who is this?
This is Bethune, but we can wait until...
We can do it. Come on up, Ms. Bethune. Okay, would the state announce?
Yes, Your Honor. This is Sade Porter versus Sabrina Bethune. That is 21 CF 1358. Your Honor, she's here on a violation this morning.
Okay, so you may have just heard the tail end of my conversation. For folks that are defendants that are here without an attorney.
Yes, sir.
You do have the right to have an attorney appointed with this new case, if you wish to have an attorney appointed.
Yes, sir.
Okay, the court's going to appoint the public defender. The court's going to enter a denial of the violation of probation, like a not guilty plea. So it will preserve your rights, give you a chance to talk to your attorney. Okay?
Yes, sir. Thank you.
Okay.
Your Honor, when is the next court date?
Next court, that's good. Thank you for reminding me. We will, why don't we come back in
Does she have any other open cases on her? Or
Not that I'm aware of. We'll come back, normally where are we at on the September 12th and 19th dockets for miscellaneous? Morning dockets.
October 11th?
Not October.
Oh.
Yeah, not, right, October 12th and 17th.
Okay, for October 12th, I scheduled 21,
And,
and for October 17th, I only have one.
okay,
And this would be an AM anyway, so.
correct. So it'll be October 17th.
Okay.
We'll continue to October 17th. AM.
He's the judge. No, ma'am, you're right. The court said that 17th, so that's what it is. Thank you.
Okay, is Haley Barnard here? You come forward, ma'am, come to the podium. Would the state announce the case?
Yes, Your Honor. This is 22 CF 2083, Your Honor. She's here for violation.
Okay, so as I stated, Ms. Barnard, you do have a right to have an attorney appointed. You wish to have an attorney appointed?
I'm okay. No, I
You're
don't.
okay. No, you don't want one?
No.
Okay. So how do you wish to plead today? Deny or admit?
Admit.
Admit. Okay. Has the state had some conversation with Ms. Barnard?
Your Honor, this is my case, and no, we have not. The state's offer is the probation recommendation of 60 days at Okaloosa County Jail.
So if you admit, I'm going to sentence you to 60 days in jail today. You want to enter a denial and talk to your attorney?
Yes, please.
Okay. Court will appoint the public defender. The court will enter a denial, and we'll come back on October 19th in the morning.
Your Honor, would you please allow me to advise her that she needs to complete the public defender application with the clerk's office on the first floor before you leave the court today to make
And
it.
that goes for all the folks that are here without an attorney. If I appoint, make sure you fill out the forms before you leave today.
Yeah. And coffee can set an appointment. Okay.
Okay.
Thank you.
Hold on. October 17th, not 19th.
October
17th,
Right.
my bad. Thank you, Madam Clerk. I don't know what I was looking at the wrong. It's September 19th and October 17th.
9 a.m.
9 a.m. Okay. Zachary Brunson. Come to the podium. Wear long pants next time you come to court.
Yes,
Take
sir.
it a little more
Sorry.
serious.
I'm sorry, sir.
I know.
Yes, Your Honor.
Okay, state, announce it.
Yes, Your Honor, this is 23 CF 436 and 23 CF 475. Your Honor, he's here on a violation this morning.
This is not his first time, is it? I've got it here as a VOP evidentiary, which means he's been here before. So, why doesn't he have an attorney? Were you gonna get an attorney?
Yes, sir. I'm still trying to save money to get with Mr. Durrell.
Okay.
Not all office, not Durrell. But I should have it by then. Yes, sir. I should be able to have his money by the end of this week, and I'll have him be able to represent me.
So we'll continue this until October 12th. Okay?
Yes, Your Honor.
So we need to move, do something, so, okay?
I take one of these, or?
Yeah.
Thank you.
Thank you. Crystal Kirk. State, would you announce, please?
One moment, Judge. This is Crystal Kirk, case number 22 CF 1974. She's charged with criminal mischief, over $200 for under absence.
This is a violation of probation, isn't it?
That's correct, Judge.
Okay. So, Ms. Kirk, you do have a right, as I mentioned, to have an attorney appointed. You wish to have an attorney appointed?
Yes,
You're going to
sir.
hire private counsel? You
Yes,
wish to have an attorney, yes?
Yes, sir.
Okay, court will appoint the public defender, and as I said, I'm going to go ahead and enter a denial on your behalf that'll protect your rights. And we'll come back on October 17th at 9 a.m. the next court date.
Okay, I have a question.
Okay.
For probation, it was just I need to finish my 24 hours of community service, which I have right here.
Judge, I would ask that we pass the case, because if she's completed her community service hours, then that would deal with the
We
violation.
can ask the probation right now.
Probation authority mentioned to me that she's good to terminate, Your Honor. She provided proof of completion.
Yes. You want to just,
Can I hear that from probation?
he wants to hear from the horse's mouth, so to speak, so.
Yes, sir. Okay, so at this point, we'll dismiss the violation.
So you're going to withdraw the vow, or dismiss it or withdraw?
Withdraw, thank you.
Okay. Very good, ma'am. So this is withdrawn, and sounds to me like you've completed your probation.
Yes, sir.
Okay. Anything else we need to do on this?
Unappoint the public defender.
Okay, thank you for, yeah, we're not appointing the public defender, so we don't have to charge you anymore.
Thank you.
Okay, good luck. Jean, or excuse me, Leah Grillis, if I pronounced your name right, I apologize if I didn't.
It's okay.
Would the state announce the case?
This is 21 CF 1074. She's here for violation this morning.
So, as you heard me state several times, you do have a right to have an attorney appointed. With this new case, you wish to have an attorney appointed?
I believe so, yes, sir.
Okay, so the court will appoint the public defender. Court's going to enter a denial, and the court will come back. We'll continue this matter until October 12th at 9 a.m. Sure. Make sure to meet up with your attorney before then, okay?
Okay.
Your Honor said October 12th.
Yes, ma'am. Yes,
Thank you.
Thanks.
You fill out that before you leave on the first floor, okay?
Okay, okay.
Okay.
Thank you,
ma'am.
sir. Have a
You're
great
good.
day.
Yes, ma'am. Mr. Harper, you ready to roll?
Sure, Judge. Most of mine are in custody. I don't know if you have any out of custody.
I have a couple out of custody.
Okay,
Your
let's
Honor.
do the out of custody program. Mr.
Your Honor, may I call, Steve Medina called Marilyn D. Bohannon.
Okay.
Ms. Bohannon is approaching Your Honor in 18 CF 1079. She appeared before the court on August 17 with proof that she had paid off her court costs, but there was some confusion that I think that we have now cleared up. She paid off $340 recently for 34 hours of community service at $10 per hour. And then that leaves basically a 4% surcharge with a $30 one-time drug testing fee that basically, if the restitution of $823.77 goes to lien, my understanding is those fees would be waived. So basically, I'm just representing that that is the status. I think the state might be agreeing to dismiss the VOP and have the $823.77 go to lien. I do note for the record, my understanding from her.
What's your case number?
It's 18 CF 1079.
Okay.
18 CF 1079. I apologize, Judge.
State?
Yes, Your Honor, that was the state's intention. It looked like all the financials as far as probation have been taken care of, except for the restitution. The state will agree. If the court will announce that the restitution is going to a lien to Buddy's Home Furnishing.
Is it just the restitution? Is that the only thing that's outstanding?
That was my understanding, Judge.
And then unfortunately, there's always for today as well. So there's a $100 VOP fee and a $150 public defender fee that has to be imposed, I think. So I think the way it works is she has a $1,000 cash bond that she represents that was paid a long time ago. And that balance, if there is any balance, might go to her, but I don't know if there's going to be any balance because she probably.
But for today, all the outstanding court costs and restitution would go to lien, and this VOP would be dismissed?
If
No,
the
it was
VOP is
just-
being dismissed, then I guess that,
Then that's what I was gonna bring up, is I don't think I wasn't gonna make her plead to the VOP.
Right.
Your Honor, so I don't think the public assistance fee applies to a situation where someone doesn't plead to the VOP. That'll save her a couple of $100, Your Honor, and I don't mind if the court gives her some time to pay before the remaining $800 goes to collection.
and Judge, the state is absolutely correct. I was incorrect. I apologize.
Okay, so tell us exactly, so we make sure and have a good record of what we're doing here.
Basically, Ms. Bohannon is agreeing that the 823.77 can go to lien, and the state is agreeing to dismiss the VOP. There would be no VOP fee, there would be no public defender fee, and it would just be the probation's terminated. The probation expired by operation of law. It's not a revoke and terminate.
Okay. So as to 18 CF 1079 in the underlying case, the court will direct that the remaining 823.77, which is all of the restitution, will direct it, give the defendant an additional. We really don't need the additional time because you're going to really just use the bond to access it. Do we need additional time?
And it also doesn't go against her license, according to one of my able colleagues. So I don't
do we
think
want to give her an additional 30 days to pay it, or just?
she just wants to use the bond and be done. She thinks it'll close out.
You want the bond applied to restitution?
Yes.
Okay.
And then that'll make it Buddy's Home Furnishing happy.
Okay, very good.
Yes, ma'am.
So that'll be, and then in your probation has expired, that's ended, and the violation of probation is being withdrawn. So you don't have to worry about this one. Okay?
All right, so I'm gonna need a memo for Buddy's with an address and a person to make the check out to.
If I'm drafting a memo, I'm worried about the $100 public defender fee.
No. The state attorney's office can send us a memo for the victim.
I will.
Okay. And it's gonna be $3.50 for us to send a check.
Okay. Very good.
Thank you, Your Honor.
Thank you.
Good luck. Thank you. Your Honor, the only other out of custody I had was a capious recall. He's not on the docket, but Mr. Day is present. Can I call him up, Your Honor? It's Christopher Day, D-E-Y. The case is 23 CF 1599. And he apparently has a failure to appear with some paperwork that he can testify to, basically gave him the wrong court date. He says he came on what he thought was the right court date. Could he just address that, Your Honor?
Sure.
I'm sorry, Judge.
I'm not going to track it, so.
Yes, ma'am, 23 CF 1599.
Okay, so, go ahead.
Yes, sir. I received the...
Go ahead, Ray. I'm going to swear you in. Do you raise your hand?
Yes, sir.
You swear affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God.
Yes, sir.
Okay, explain what
I was given a court date by the bondsman here, August 23rd at 1:30 p.m. I arrived there August 23rd here, actually at 1:15 p.m., making sure I was early. They couldn't find my name anywhere, so they looked. The clerk looked it up and said that
Who's
I was
handling
given
this
the
for
wrong
the
date.
state?
This is my case.
So, you're the one who needs to be signing off on this.
I was told that and I spoke with the bondsman as well, and he said that they were given the wrong date at the jail, and so they wrote the wrong date on that paper, so I showed up on the wrong date.
Agree to withdraw the case?
Yes, Your Honor, that does have
Withdraw the case,
court
sorry
date
for
on
the
it.
confusion on that.
Thank you.
Your Honor, Mr. Day apparently is
Now, what's
like...
the next court date for?
Did he miss an arraignment or a pretrial?
That was, sorry.
You want to just enter a not guilty?
Could we go ahead and waive the plea of not guilty and set him on October 9?
We don't have any information on it.
Oh, okay. Well, then we can't do that.
Okay, let's put him on a next arraignment, and so we'll come back on September 12th at 1:30 for arraignment.
Your Honor, does the court meet
October 12th. Sorry. We're going to give you the wrong date again. That's before today, so that won't work.
10/12. And that, will that be at 1:30 p.m., Your
That'll be
Honor?
at 1:30, correct.
And I don't know if he has filled out the public defender application. I'm asking him to do so on the first floor if he hasn't done so already. Thank you.
Thank you.
Thank you, sir. Thank you.
Thank you.
Thank you. Thank you, Your Honor. Those are my custody that I'm aware of.
Question, Madam Clerk?
No, we have the application, sir.
Oh,
For September 6th, I got it. Sorry, I was in the middle of
they'll let him know. I'll check it.
Your Honor, if I can call Parker Doria.
Okay.
Your Honor, this is Mr. Doria before the court in 21 CF 2985, 20 CF 2356, and 20 CF 2010. If we can continue Mr. Doria's cases without subpoenas, he's working on some of those outstanding obligations as well as having to restart his treatment. My anticipation is next cycle will either be an evidentiary set or a plea to the court.
So October 17th?
Yes, Your
Good
Honor.
time? Okay. So we'll continue this October 17th at 9 a.m. without subpoenas. Hopefully be some resolution at that time. Good luck.
Your Honor, next I've got is going to be Dayton Grag.
Okay.
Mr. Grag is making his way up, Your Honor. He's before the court in 22 CF 1893. After speaking with him in the state, it sounds like we're all on the same page with an inpatient program. Mr. Grag is going to look at some options. I know the state had mentioned Keaton as an option. If we can continue his case without subpoenas, we'll need to get some of that screening completed.
October 12th or 17th?
17th, Your Honor.
Okay. We'll continue to October 17th at 9 a.m.
Thank you, Your Honor. Your Honor, next I've got is going to be Miss Alicia Irby.
How do you spell the last name?
I-R-B-Y.
Very good.
Ms. Irby's before the court in 22 CF 2875. She'll be admitting the violation before the court. I do want to let the court and Ms. Irby know that I spoke with probation. Part of the requirement is the drug patch. Probation doesn't do the drug patch, so she'll have to go through Lakeview to get the drug patch attached. It's not in the plea agreement. Does the court want me to put that on there, or just the requirement?
As long as the plea agreement is sufficiently clear.
Yes, sir.
Well, what does the plea agreement say?
Basically, she'll be required to wear the drug patch as part of the reinstatement.
Okay. So, and ma'am, you understand that, you know, that it's over in Pensacola to get it?
Lakeview or?
Is that here?
Lakeview. See,
Lakeview has an office here now?
Yes, Your Honor.
Okay. So you gotta go to Lakeview to get it. You understand that?
Okay. Yes.
You don't sound like you. And if you don't, just ask the question.
Is the transportation wise, I don't have the means for a ride.
Checking that for that.
Yes.
So you just gotta make sure to check in there.
Yes.
You gotta put something to be anyway.
Yes.
We're good?
Yes, Your Honor. And this is a misdemeanor violation, Your Honor, so this will shoot.
Thank you. Would you announce the plea?
Yes, Your Honor. Ms. Irby will admit the violation before the court. We're going to maintain the withhold. We're going to modify and reinstate her supervision. We're going to extend her supervision past the current termination date by 3 months, which was what we have for tolling. She'll be required to do a substance abuse evaluation, any recommended treatment. She'll have to have the drug patch attached. I would think the state will probably want that within the next 15 days, 20 days to give the time to get that arrangement, to get it correct.
State?
That's correct.
Okay,
And then the standard cost, the prosecution of a defender fee.
very good. Is that state in agreement?
That's correct.
Ma'am, would you please raise your right hand? Just need to ask you a few questions. Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God? Yes? You're speaking to that mic for me. I gotta
Yes,
hear
Your
you.
Honor.
Okay. You can put your hand down now. So I just need to ask you a few questions. You heard your attorney state the terms of your plea agreement.
Yes,
And
sir.
I see those same terms are written on your written plea agreement that you signed.
Yes, sir.
Did you read this closely?
Yes, sir.
Did you go over it in detail with your attorney to make sure you understand it? Got a lot of legal stuff in here that I just want to make sure you had all your legal questions answered. The big thing is that you're waiving some valuable legal rights. Okay? You're waiving the right to go to a hearing, force the state to prove their case. You're waiving that and say, no, I don't need that. I want to have a final resolution today. Is that what you want?
Yes.
I believe that's in your best interest.
Yes, sir.
Very good. Based upon that testimony, the court will accept your plea. There will be a withhold of adjudication maintained. Modify and reinstate probation, you're going to extend it for 3 months. And you have the added condition, importantly, the substance abuse evaluation within 60 days. And any recommended treatment has to start within 90. And you got to wear the drug patch. Okay? Fees and costs standard, you got to be paid during the term of the probation. Okay, any questions?
No, Your Honor.
Okay.
And Your Honor, just for probation, we're going to ask for 15 days to get that arrangement, to get the drug patch put on.
Very good.
Thank you.
Okay. Good luck.
Thank you, Your Honor.
Your Honor, next I've got is going to be Rebecca Jordan.
Okay.
Your Honor, this is Ms. Jordan before the court in 20 CF 2645. So we do have a plea agreement to be filed in Ms. Jordan's case, if I may approach.
You may.
There will be a modification, Your Honor, so this motion will not be necessary.
Thank you. Would you please announce the plea?
Yes, Your Honor. Ms. Jordan will be admitting the violation before the court. We're going to maintain the withhold. We're going to modify and reinstate her supervision. We're going to extend her 12 months from today. Assess the standard cost of prosecution, public defender fee, complete the original requirements. And I meant to ask before we got going if the state had objection to sending those outstanding court costs and fees to collections. That way we're just focused on that community service work and substance abuse.
No objection.
So all the fees and costs will go to collections right now?
Yes, Your Honor. Ms. Jordan, I discussed, her license was already suspended, so that's not going to be an issue. We really just are trying to get her to finish that substance abuse and the community service work, and this kind of avoids a potential violation for monetary reasons again.
Gotcha.
Judge, I would say that based on my conversations with the defense, I do not believe that this defendant is going to be able to pay. So I think that it's just best to send it to collections at this point.
Okay. Very good.
Yes.
We need to add that.
I can do that, Your Honor.
Okay, very good. So ma'am, go ahead. I'll wait for you just a second. Mr. Gates.
Will I have to come back here to get liquidation of
Probation, does she have any cost of supervision at all?
I've had that system.
Okay. If we can waive that cost of supervision, both your arrearages and forward, that'll also save her some money as well.
Put it down. Put it down.
Yes, Your Honor. Try to make sure that Ms. Jordan doesn't have to come back on an issue in the future.
All right.
I have a disabled father that he lost his leg, and I'm having to fork out money as it is to pay a babysitter to sit with him 24 hours.
I understand. Okay. Ma'am, would you raise your right hand? I just need to ask you a few questions. Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of the plea agreement that are contained in your written plea agreement that you've
Yes.
signed. Did you read this closely and go over it with your attorney,
Yes, sir.
make sure you had all your legal questions answered?
Yes, sir.
Okay. and you believe that this is in your best interest here today?
Yes.
You understand that by entering this, you're waiving the right to go to a hearing, and this will be a final resolution of this violation here today. You
Yes,
understand
sir.
that?
Yes,
Okay.
sir.
Based upon that, the court will accept your plea. There'll be continue to have a withhold of adjudication, modify and reinstate probation. Will extend it 12 months from today. They'll have the cost and fees that will go to collections immediately, and the court will waive all past and current cost of supervision going forward. So past and then going forward.
Thank you so
Okay?
much.
So you can focus on your caregiving costs and hopefully get through this probation.
Thank you.
Any questions?
No, sir.
Thank you.
Your Honor, the last out of custody I've got is going to be Damon Kennedy.
Last name again?
Damon Kennedy. K-E-N-N. Your Honor, we are before the court today in a motion to withdraw filed by the Public Defender's Office based upon the monetary amount posted in Mr. Kennedy's case.
Okay. So what's, explain.
Statutorily, Your Honor, if the defendant posts above, I want to say a $5,000 bond or more, they're presumed not to be indigent. And in Mr. Kennedy's case, he posted a total of about $65,000 bond in order to be released on the charge for the court.
State? I mean, obviously the state doesn't have a dog really.
State doesn't really have a dog in this race, Judge. I have no objection.
Okay. Court will grant your motion to withdraw
Yes,
as
sir.
legal counsel for the public defender. So, Mr. Kennedy, are you planning on getting another attorney? The thing, so you understand what's going on? So, you have a right to have an attorney, okay? And the way we say it, and the way it is that if you can't afford one, we'll appoint the public defender. But in this case, because you post such a big bond, they say, hey, you've got enough money. So I'm not allowed to appoint the public defender, so he's getting off the case. So you now don't have an attorney. Okay? But you still have the right to an attorney, and quite frankly, you probably need an attorney, because everybody needs an attorney. So are you going to get an attorney? Right now, you don't have an attorney. You understand that?
Yes, sir.
You going to try and get one?
Your Honor, he is scheduled for plea date on October the 12th. If we could just have him come back that date and then speak with some attorneys before then.
Very good. Is there a plea on the table for Mr.?
It's a trafficking charge, Your Honor. I'm going to say there's probably not a plea that Mr. Kennedy's going to want to take.
There's a plea, but there's not one that would be.
Yes, Your Honor.
Which is all the more reason why you need to get an attorney, sir.
Yes, sir.
Okay, so, we'll come back, when is plea day, when's the next day?
October the 12th at 1:30. I'll write that down.
Come back October 12th at 1:30 for plea day.
Okay.
Okay? Very good.
Thank you, Your Honor.
Thank you.
And that's my last out of custody.
Yes, sir. Any others, Mr. Medina, and then we'll start?
Only in custody to my knowledge, Your Honor.
Okay. Very good.
Thank you.
Mr. Harper, we'll do Mr. Harper's, then we'll take just a very short morning break. Of course, Mr. Harper's got a few here.
I do have a couple, Judge.
Can you put Jessica Green in any kind of
Judge, this is Jimmy Case, and it's 12 on the docket. He's before the courts on 22 CF 1820. This is the first time up for me, Judge. I think I just need a little bit more time to negotiate a resolution in this case. If we can set this for the next miscellaneous court date, I'm hoping that we could, without subpoenas.
Okay, we'll continue this till October 12th at 9 a.m.
The next one, he's not in
Now,
custody.
on this case, you know, there's been a previously entered plea to the bench on this case. What's that? You're welcome to, you can keep it, we can.
This was with his
That's
previous
why we
attorney.
were up for a sentencing today, which, fine, I'm not gonna press you on that today if you're not prepared, but he pled to the bench.
Judge, if we can just leave it set for October 12th, I'll come speak with him and try to understand where this
Keep
case
that-
is at.
Keep that table.
I'll talk to him about it.
Okay, so we'll continue to October 12th at 9 a.m.
The next one that's on the docket is Sean Coy, Judge. He is not present. That's 22 CF 32 and 22 CF 161. Judge, Mr. Coy is in the custody of the federal government. I think the state may have an announcement.
Yes, Your Honor, at this time, the state is going to dismiss both of these cases as the defendant has received a pretty significant federal sentence. He'll be in Bureau of Prisons for a number of years.
Okay? Court will null process the two cases.
Judge, the next case is Mr. Donaldson. He's before the court on 22 CF 1617. May I have just a moment?
TJ.
Judge, with respect to Mr. Donaldson, we're going to ask.
Just if they're somewhere else in the courthouse. Okay. Go ahead, Mr.
Judge, Rudy Harper on behalf of Mr. Donaldson. We're going to ask to set this for the pretrial conference on October the 11th. I think we're very close to a resolution.
So we'll come back on the pretrial on
Yes,
October 11th? Okay. Very good. We'll continue to October. I'm sorry.
Or just put it back on pre-trial.
Is this for,
This
we
would be,
anticipating a plea?
we had set this for a status. We're negotiating toward a plea, but.
We'll just set it on standard pretrial. and
Yes, sir.
If
And
it please, we'll go from there.
Yes, sir.
Okay.
Eric Edwards?
Judge, next is Eric Edwards, 21 CF 1210 and 21 CF 2883. Just one moment.
Single plan is not seen either of those attorneys.
Judge, Rudy Harper on behalf of Mr. Edwards, we're going to ask to move this to 1011 on the pretrial as well. We are talking, and we just need to finalize the final terms of the deal, Judge. We just haven't got that concrete yet.
Very good. We'll continue this until October 11th at 9 a.m.
William Hackett?
Judge, this is William Hackett, 23 CF 183. If I may just have a moment. Are you sure this is what you want to do? Sign and date there. $9.19.
Hey, I'm scheduled for a court date on the 11th next week. Can we make sure?
No, this will be that. Judge, Mr. Hackett is before the court on 23 CF 183. At this time, he's going to withdraw his previously entered plea and enter a plea of no contest. This will be a plea to a lesser included offense of possession of controlled substance without a prescription as to count 3. As charged is all remaining counts to be adjudicated guilty, be placed on 3 years of probation, be assessed $615 in court costs, $150 cost of defense, Tenant complete a substance abuse evaluation and any recommended treatments. Evaluation to occur within 30 days. Any recommended treatment within 60. Undergo random year analysis. Maintain employment or have 5 job applications per week until employed. And with respect to the misdemeanor count 1, there'll be 11 months and 29 days of probation to run concurrent. If I may approach.
Would the state approach? Hold on a second.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Is the defense okay with the score sheet?
Yes, Judge.
So is the state okay with is that the plea agreement with the state?
That's correct, Judge. Based on the evidence that the state has, we believe that this is an appropriate resolution of the case.
Very good. Mr. Hackett, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So, Mr. Hackett, you heard your attorney state the terms of your plea agreement, and I see that you have signed the written plea agreement. Have you read this closely?
Yes, sir.
And did you go over it in detail with your attorney to make sure you understood the plea agreement and all the legal issues involved?
Yes, sir.
Importantly, you're waiving the right to go to a trial, to contest all these things. You're also, so you can get a final resolution today. So this will be a final resolution in your case here today. You understand that?
Yes, sir.
You believe that's in your best interest? Nobody threatened or coerced you to get you to enter into this?
That's correct.
Okay. Based upon that testimony, the court will accept your plea. It will be a plea to a lesser included offense on count 3, possession of a controlled substance without a prescription. And you'll have, it'll be as charged as to all the remaining counts. There'll be an adjudication of guilt on all counts, 3 years probation. I assume the 3 years probation is going to be concurrent.
Yes, sir.
They're each 3. So we might need to add that little word in there. And then you've got the court costs, but you do have a substance abuse evaluation and recommended treatment. You got to begin that within 30 days, maintain employment. And as to the misdemeanor case, it's 11.29 months probation concurrent on count 1. So it's on the 2 felony cases, it's 3 years probation concurrent.
Yes, sir.
And the other one is 11.29 concurrent. Okay. You understand what we're?
Yes, sir.
Basically means it's a total of 3 years probation. It's three, and then the misdemeanor is only 12 months, so you can't go more than that. So it's 12 months. All running the same time. And you do actually have the right to appeal this, even though you're just entering into this today. Go ahead.
All I did is add that all supervisions. Let me approach that.
Okay, any questions?
No, sir.
Okay, thank you.
Right this way, sir. Willie King.
Judge, this is Willie King. He's before the court on 17 CF 3361, 18 CF 535, and 19 CF 1934. Let me have just a moment. Judge, I've spoken with Mr. King as well as his family and as well as the state. I think at this point we're still negotiating toward a possible resolution to these cases, but in an abundance of caution, I think it's appropriate to set this for an evidentiary hearing. I have been speaking with the state. I think that we're coming closer to a resolution, Judge, but this does need closure one way or the other. So the next available afternoon hearing date.
How long are we going to need
Judge, I would anticipate if this hearing were to proceed, the state probably will call one witness, and I may call one or two, maybe 2 hours total.
At the most, Your Honor.
But I'll let you know if that's, you might take it right.
Oh, we gotta go through Ms. Van Bossel. Sorry. So TBD. So we'll get it done as soon as possible. 2 hours.
And I need to coordinate that with your JA judge?
Yes.
Okay.
And this is going to be as to 19 CF 1934, all three.
All three.
Put them all together, please.
Yeah.
And Mr. Harper, just for your client's knowledge, if we proceed to the hearing, any offers of resolution will be withdrawn.
And Judge, the state made me aware, and I'm putting on the record, advising my client on the record, please do not mail anything else to the state attorney's office. It's okay. We'll send for another hearing date. And we can still.
Try this way, Willie. Darius Wilson.
Judge Darius Wilson is before the courts on a number of cases, 20 CF 998, 20 CF 999, 20 CF 2791, 21 CF 1350, 21 CF 1490, 21 CF 2700, and 22 CF 189. Judge, I've spoken with my clients. I think that we're not able to come to terms with the state at this moment, so he's asking for an evidentiary hearing. I will continue to try to negotiate something with the states. I don't think.
How long of a hearing do we anticipate?
I think worst case we would call 2 witnesses. I think the state will probably call those same witnesses actually.
I would think so, Judge. My concern is the number of cases, though. Yeah, I don't think this would all be done in one evidentiary hearing, will it? It would all be one.
I think that this is a technical violation. These are technical violations.
I'd say 45 minutes.
Worst case scenario.
Say an hour.
Yeah. To include argument.
Again, you gotta
coordinate with the JA judge. So.
1 hour.
Your Honor, Mr. Medina is ready on all of his inmates except for one. Would you like to go into those or take a break?
Let's take a short break.
Yes, sir.
You're finished, aren't you, Mr.?
Yes, Judge. That's all I have today.
Okay.
So we'll take a short 10 or 15 minute break.
Yes, sir. All rise, please.
Congratulations, Crestviews' very own Dixie Dan Powell of Powell Injury Law for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestviews historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Dave's Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at davestilepros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Fat Boy's Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
The Cottage Formalwear, located at 648 North Wilson Street, has all your needs for looking your best. We have homecoming, prom, and pageant dresses. We have tux rental suits, vests, ties. Need something casual? We have that too. Shop Hometown First and visit us on Facebook at the Cottage Boutique and Formalwear. We're located at 648 North Wilson Street. Call 850-682-2446.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Please be seated.
Jenny Baker.
Mr. Medina.
Your Honor, Steve Medina with Jenny Lynn Baker, docket 36, I think, 22 CF 2998, 23 CF 712, 23 CF 713, and 23 CF 1636. Your Honor, Ms. Baker, I think she's already entered a denial on the VOP. We brought her back for an early plea. Under the old policy, if the PO recommendation was Keaton, sometimes the court would go ahead and enter a sentence for Keaton, which she wants. But just so happens after I noticed it for an early plea, we got I saw an email that had been sent out very recently from Keaton's officer saying that no, they've got to do not sentence them prior to getting the Keaton acceptance. So I apologize to the court. We just need to continue her to October 11. We've also applied her for Phoenix House, and hopefully she'll get Keaton or Phoenix House by October 11.
Okay. This is on VOP, right?
Yes.
So let's bring it back on. The only reason I'm saying
There is a new, sorry Judge, there is a new law case that I anticipate the state is going to be Mill Crossing 23 CF 1636.
So we'll come back on a regular pretrial. I was just wondering whether we needed to come back on a miscellaneous or pretrial.
Yes, Your Honor. And could I put one other thing on the record? I've discussed it with probation and Assistant State Attorney Sharpless, and I'm going to be doing an email that it puts the Keaton person in the loop. But basically, there were common pocket knife issues in the violation of probation, and everybody's on board that they were not weapons. So we're going to work out with the state where that will be clearly removed from the VOP so as not to be an impediment to her getting the drug treatment that she needs.
Okay.
Thank you.
Sounds good.
Thank you.
Thank you.
Sarah Benning. Your Honor, Miss Sarah Linnea Benning is before the court in 22 CF 2021, and she's signing the agreement to resolve her VOP, Your Honor, that the state has previously signed. Thank you.
Thank you.
May I approach, Your Honor? And it was for misdemeanors, so there is no score sheet.
Thank you.
And I'm going to provide probation a copy, even though it was on misdemeanors. I think JCS might have been involved, but maybe not. Is this JCS for Sarah Bennett? Okay. Your Honor, Steve Medina with Sarah L. Benning in 22 CF 2021. She will be resolving the misdemeanor VOPs for an agreement that's been signed by all parties. She was previously adjudicated guilty to misdemeanors. There will be revoke and terminate supervision, concurrent 4 months Okaloosa County Jail with credit for all time served, $100 VOP fee, $150 public defender fees, Your Honor.
State.
That's correct. That's the state's agreement, Your Honor.
Thank you. Ms. Benning, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of your plea agreement. I see those same terms are contained in a written, you can put your hand up. In your written plea agreement that you've signed, my first question is, did you read this closely?
Yes, sir.
Did you go over it in detail with your attorney, make sure you had all your legal questions answered? You do understand that this will result in a jail sentence. You're already in jail, but it's a jail sentence of 4 months. You'll get credit for all time served. You understand that? You have a question?
So I've already served 5 months.
If you've served 5 months, then you'll be let out. But it's, I don't know what that number is because I don't calculate.
And Your Honor, I can't make any representations on that either. I did note to her and to the state, and the state modified its original 6-month jail offer because she had resolved on August 1st of 2022 a misdemeanor case that might have used up 60 of her days that were credit. So therefore, I really can't conjecture, not that I ever would anyway, what her time served is. But we made it, the state basically moved it from 6 months to 4 months in the offer to give her some leeway with respect to that misdemeanor resolution.
So with that kind of exchange and knowing that I can't give you a definitive, hey, you're going to get out today because you've gotten all credit, enough credit for time served. Are you still wanting to go forward with it?
You want that? Yes. Yes.
And you understand that by entering this plea agreement, probation will be revoked and terminated, and you'll have a final resolution of this case. Do you understand that?
Yes.
You sure? You've hesitated there. If you got a question, I just want to make sure you get this. You're not going to a trial for this. You're waiving the right to go to trial. This will be a final resolution.
It's been intermittent, on and off.
What's that?
I've been on and off probation for 3 years for a DUI. So there's been a reverse remand. Go ahead.
Ms. Manning, may I just address the court? I just wanted the court to know that sometimes she's been wearing a white outfit, and if I need to approach and explain things, but I know that she knows what she's doing today. I don't have any question about her current situation. Thank you.
Very good. Well, this will be, you're being sentenced to 4 months in jail, credit for time served. It looks, you believe that you've gotten sufficient time, but whatever that credit is, and if you've gotten more than 4 months credit, you're done. You're done with probation. You're done with it. The fees and costs any fees and costs will go to collection. We probably need to put that in there, don't we?
The court costs have already been.
Your Honor, may I add that would the court allow her to have 6 months prior to monetary obligations to go into collections?
Yes.
I'm already in collections, I think.
Yeah, so. I understand, but this is not going to hurt you to have 6. It's not going to make you do anything.
To sign that in permanent marker like that to represent, I believe it's with an X where you allow me.
Yeah,
okay.
I just wrote 6 months before it goes to collections.
Okay, very good. Any other questions, ma'am?
Yeah, no, I'm already in the diminishing returns, so we are already in collections.
Thank you, ma'am.
Good luck.
Thank you, Your Honor.
All right.
Thank you.
Take care, guys.
Good luck.
Thank you.
Right this way. Rhonda DeWitt. Just keep doing Steve. Yeah, we're going to do all the guys. We're doing everyone except for 26.
Your Honor, Rhonda M. DeWitt is before the court, 23 CF 688. She was, let's see, number 41 on the docket, I believe. I inquired with the state if we were going to be able to maybe do a community control or drug offender probation deal today. She is representing that she can do drug offender probation, that she has a tent that is near probation offices and would like to do drug offender probation. If we can't resolve it today, we'll just enter a denial. Does the state think we can do a drug offender probation deal? Even though she's had homelessness issues, she thinks she can now do drug offender probation.
Your Honor, I told Mr. Medina that I will talk to her officer about that. So I don't think we're gonna be able to do that today, but if we can bring her back on the next soonest miscellaneous date, I think I'll be able to do that prior to that date.
Okay, so we'll come back on the next miscellaneous date, which is October 12th at 9 a.m. Hopefully you can get it, okay?
Okay.
Good luck.
Thank you.
Thank you, Your Honor.
I can throw
No,
these.
no, please, right now.
That's right.
We're just gonna,
Just let me hold on.
Okay, okay.
It'll confuse things.
Okay.
Daniel Askew.
Mr. Medina.
Your Honor, Steve Medina with Daniel Askew, A-S-Q-U-E, in 19 CF 3282, docket number 35. Mr. Askew and I have agreed that he would like to go ahead and enter a denial to the VOP. The state's offer was a DOC offer, and he wants to be evaluated for Keaton and Phoenix House, and I've discussed that with the public defender's investigator to further that pursuit, Your Honor.
And so we'll enter a denial. When do we want to come back? We can come back October or November?
I think it's October 12th, or 15, or
Let's try October 17th.
17th, yes. And hopefully we'll get him into one or both places by then, Your Honor.
Okay, thank you.
Thank you. Israel Chartrain.
This was a Israel King Chartrain before the court on a Nelson motion that he filed and has been noticed for today, Your Honor, in 22 CF 2721 and 22 CF 3012. That's docket number 39.
Okay. So, Mr. Chartrand, would you please raise your right hand, sir? You swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God.
Yes, sir.
Okay, so just need to ask you a few questions.
Sir.
Basically you have, well, let me ask you, are you wanting to discharge your attorney to fire him? What do you want the court, what are you asking the court to do here today? I understood you want a different attorney.
Yes, sir. You told me if I wanted a different attorney, you instructed me to file a Nelson.
Right.
And you would go ahead and handle it then.
That's right, and that's what I'm doing now. So
yes,
I'm confirming for the record, under oath, that you want to fire your attorney.
Yes, sir.
Okay. Now, you have a right to fire your attorney. Let me just say that to you straight up. Nobody can force you to have an attorney. Okay.
Yes, sir.
But in order for me to appoint somebody else,
yes, sir,
I've got to ask you a few questions because I have to make a ruling that your current attorney has not rendered you effective representation. Okay?
Yes, sir.
That he basically, didn't handle the case properly.
Yes,
so,
sir.
Why is it that you think that your client, your attorney, was not rendering effective representation?
The case was already moving along before Mr. Medina got reassigned to me. So in saying that, the case was gaining evidence that it needed. I spoke with Mr. Medina and I went to explain about my letter that I've sent to the court, and I went to explain that everything that I allocated in the letter is backed up by factual documents. And I explained to him that
so you're talking about evidence in the case?
Yes, yes,
backed
yes,
up
sir.
by document.
Yeah, everything's backed up by a document. I've not said nothing out the way, and I'm kind of really disappointed because Mr. Medina, all he would have to do, and I owe Ms. Sharpless an apology because I looked at her kind of weird because I thought it was her, but it was really him. All he had to do was compile the information and let her look over it, and she could have been in a better position to make a ruling.
So what type of information did you provide? I don't want to know the substance of it. I just want to know What are we talking about?
I released confidential records of mental health records.
Mental health records?
Yes, sir. Showing that I have a mental illness, showing that I was under care, showing that I was stripped of my medicine when I came to jail, showing that I was put on probation, showing that I violated because of unable to obtain my medicine, and backed up with another evaluation that just confirmed everything that I said in the beginning. And I got frustrated because I felt I was facing an uphill battle trying to explain that to Mr. Medina, and all he had to do was give it to Ms. Sharpless and let her see it, and then she could have been in a better position to offer a reasonable
So you're
offer.
saying you provided a substantial amount of substantive information to buttress your case,
Yes, sir.
and then Mr. Medina didn't do anything with it? Didn't provide it to the state as you didn't show that you feel that it would have.
Greatly. I probably wouldn't be here talking to you if he would have just done that. I mean, that's how I look at
Anything
it.
else? Any other issue? Without what I'm going to do here in a second, I'm going to ask Mr. Medina to reply.
No, I had a little thing wrote up, but I mean, I gave you actually all the particulars of it. If he just would have showed her, she would have been in a better position to make a determination. And it's by a reasonable showing by evidence. It's not nothing I said, or it's just showing by the evidence, Your Honor. That was it. I know VOPs are funny. I understand that. They're highly unwinnable. Usually people just violate and they don't care. I understand that. But I have a mental condition and I couldn't get my meds. And I don't want to, and I'm not making an excuse, but I'm not going to go down like that because I didn't do it. I didn't willfully violate. And I feel.
Do you believe you didn't willfully violate the terms of your probation because you had some mental issues, and then you provided that documentation to your attorney and he didn't do it?
Yes, sir. Because she would have been Ms. Sharpless would have been in a better position to deal with me. But Mr. Medina just wanted me to admit a violation and take what she was offering.
Mr. Medina.
Your Honor, last time we were in...
Would you make sure and pull your mic over
Oh,
there, make sure. And I think I need to swear you in, don't I?
That's fine.
Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God? Go ahead.
Yes, Your Honor. Last time we were before the court, Mr. Chartrand fired me, and then he unfired me when he realized that he had questions about his competence to represent himself. So I was unfired and did exactly what I said I would do after that court appearance, is that I sought an addendum report from Dr. McDonald. That is in the works. I advised him before the hearing, and I also filed a motion for continuance that said what the status was that Dr. McDonald had done on retainer agreement with public defenders, then Assistant Public Defender, I think it's Ryan Mallett. He had contracted Dr. McDonald to do a mitigation report, which when I got reassigned the case on July 21st, we reached out to Dr. McDonald to see what the status of that was. Basically, meanwhile, on August 10, I received a 5-page handwritten pro se filing by Mr. Chartrand in which he contended that the alleged violation of his community control was not willful due to mental illness, and was also asking for mitigation of sentencing. So it's kind of as is rather typical.
What happened since our last hearing?
No, that was before. I filed a motion for continuance on August 15, Your Honor. The hearing was August 17. And basically, I made it clear to the court and to Mr. Chartrand that I had only a mitigation-related report from Dr. McDonald, and that if he wanted to challenge willfulness with Dr. McDonald's support, I would have to get an addendum report. And that's what I have sought. I do not control how quickly Dr. McDonald works, but that's in the works, and if he wants to challenge willfulness, that's totally his right. But if he wants to be able to rely on the admissibility of an expert report, then I have to have one that addresses the issue of willfulness. And Dr. McDonald made it very clear to me, and I made it very clear to him, that willfulness is a different issue. His sometime fiance, sometimes alleged victim, provided some information to Dr. McDonald. She's been contracted to provide an addendum report. As soon as we get that, we'll provide that. But Dr. McDonald had all those medical records which were provided by the Public Defender's Office.
The addendum from Mr. McDonald?
From Dr. Brandy McDonald, female, Your Honor.
That's pending?
It's pending, Your Honor.
Requested it and it's...
We've requested it, and I can't make her work any faster. And she expressly said that willfulness was a different issue. So not only did he have a report that might not come in on the willfulness issue, but I had an expert. I could not in good faith even represent to the court that Dr. McDonald felt she had addressed willfulness in that report, because she expressly told me she had not made a decision on willfulness in that report, and I informed Mr. Chartrand of that. Thank you.
So you acknowledge that the information that he sent to you that he felt was relevant and would win the day, you agree with him. You didn't send it on to the state because it didn't address the issue of willfulness that he's seeking to really object to the VOP on.
Your Honor,
correct in the way I'm explaining?
I don't know what he's saying.
But he said that there was a whole packet of information he sent to you, and all he wanted you to do is send that to the state. This
is the first time I'm hearing that was the issue of the Nelson hearing. But we did provide, Your Honor, to Dr. McDonald, the Public Defender's Office provided to Dr. McDonald, the expert, all that information, and then she took that into account as she saw fit. It was provided, the medical records went out to Dr. McDonald according to my assistant back in June.
So, Mr. Sharkey, you're shaking your head now. What do you disagree?
Well, he evaded your question, but I mean, you asked him,
I'll explain exactly what. Let me be clear. He basically said if willfulness, the willfulness requirement of VOP requires certain things to be done. And he's basically saying the stuff you gave him didn't have anything to do with willfulness. If you want to do that, then you need to get some specific information from the doctor as it relates. He did that, and he's waiting for the doctor to give it to him.
Your Honor, I didn't say that it had no bearing on it. Dr. McDonald has the records that we obtained, and we provided her whatever medical records there are for her consideration. I'm not saying that she doesn't take those things into account, as well as information she got from the jail and so forth.
I didn't say it, but it doesn't address the specific issue.
Right.
They're waiting for some further information.
Could I just say one more thing, Your Honor? Probably not, but let's just look at it. Even in the absence of a non-willful defense, and having rejected the theory of my inability to not willfully violate my probation, the only logical explanation to account for my behavior and failing to comply in the state's opinion that I just violated would have been just as easily they could have inferred from the information that I had a mental illness and I was unable to obtain my medicine. Simple cause and effect. Because counsel didn't present the evidence, that's why I think we're going through all this.
May I respond?
The doctor she evaluated me that just backed up what I was getting treated for. The doctor did evaluate me, and it matched what I was getting treated for. I don't understand. He says an addendum, but from my very meager lack of knowledge, I couldn't find this thing except in 2 cases what Mr. Medina speaks of. They use it in real estate and other laws. He hinges everything on the Medina when there's enough factual basis in the case already to infer that I have a mental condition and I was unable to obtain my medicine. I'm not saying this, it's not complex. That's really all I can say, Your Honor.
And Your Honor, we had this discussion his last court appearance. If he wanted to go forward without an expert report supporting him, then he could have gone forward. He considered that and he decided he didn't want to do that, and so the court reappointed me, and I said, okay, we're going to go forward and seek the addendum report. He did, pro se, before the last court appearance in his August 10 filing, reference case law, and he had also, I looked at cases, but basically cases where you have a psychiatrist supporting the willfulness issue is different than a case where I don't yet have a licensed psychologist on that issue. So I need to try to get that to where it fits within some of the case law that he cites.
Okay. So, Mr. Chartrand.
Yes, sir.
The one thing that I can't rule on, I can't rule that the attorney is ineffective because you guys have a disagreement about how to proceed. There's just a disagreement, and I don't see that represents ineffective counsel. Now, you have 2 options. We can continue to move forward, and you can still fire Mr. Medina. You can do whatever you want with your case. Or, what seems to be the more logical thing to do is to wait for the addendum from Dr. McDonald, which is in process, which will give you a much more definitive answer one way or another, and kind of continue to move forward. But if you want, but I'm not finding that there's no reasonable cause that Mr. Medina is rendering ineffective counsel, or ineffective representation. You guys, I hear it. You have a disagreement. I'm not really ferreting out and saying, I agree with Mr. Medina, I agree with you. You're both making arguments. I'd have to really look at all the documents, and I'm not doing that today. The question I have today is whether or not Mr. Medina is rendering ineffective counsel. And that's, the court doesn't find it. I don't believe that's here. So what do you want to do here today? I'm not good. You can still fire him. You can do whatever you want, but I'm not going to hire another.
Last time I was before you again, Your Honor, you showed me that I don't know how to move around your courtroom. Yeah. So I'm out of my depth. You said to hire a mechanic because you're not a mechanic. I was trying to get a mechanic. I feel like I got an oil change specialist. But I don't know what to say no more. I can't be in your courtroom unchaperoned or without a mouthpiece. I don't know how to move. You made that perfectly clear.
I asked a couple questions. It made it clear to you. I think people that operate on their own, with rare exception, and it's very difficult, particularly in criminal actions. Even reading the cases. I mean, lawyers go to school for 3 years trying to learn how to interpret cases. That's the whole purpose of legal education.
Yes, sir.
And they expect you to come in and read with legal words and all that, and read that same case and understand it just like you would if you were a lawyer. It doesn't make any sense.
Yes, sir.
In some cases you can, but a lot of cases you can't. So I'm denying and I'm hearing you say you don't want to fire your attorney right now. We need to proceed forward. Let's see what happens with things. But because you don't feel like, and I think correctly so, that you're able to represent yourself. And that doesn't mean you're not smart. It just means this is not what you're trained to do.
I just am at all, because it just is out of control. Like, it's simple. I mean, I could understand if I had new law violations.
Well, let's see with what Dr. McDonald, maybe Dr. McDonald will agree with you exactly. If Ms. McDonald, Dr. McDonald doesn't agree with you, well, you know, you may not like the outcome. I don't know. But if she agrees with you, then you've got a strong case. So do you have any sense for when Dr.
No, I don't, Your Honor, and I think that it was a to-be-determined court date that might be sometime out in the future, so we'll continue to try to reset an evidentiary hearing. I don't know when
until we get that report.
Your Honor, I can...
If what I would do is, I'm going to go ahead and set it for October, just kind of a status conference, October 17th. But if it's done before you get the report in, then, and you want to set it for an evidentiary based upon the report, and after talking with opposing counsel, depending on what it is, then call my office and set it.
Yes, Your Honor.
Your Honor, I can tell the court Dr. McDonald's about a month backed up, so hopefully...
Well, he's already, but he submitted it a while ago.
So
it should be in the next month, he should get something.
Yes, correct.
I would think.
Hopefully.
Hopefully. I can't.
And Your Honor, the state
I understand you're frustrated. Hell, anybody that's in there and you know, having to come in here in Shackleton and Green Road, you want to try and get out, you don't think you should be in there, you're frustrated. I get it. I really do.
Sorry. Just so the court knows, Mr. Medina did file in reciprocal the previous report obviously without the addendum that Dr. McDonald had done, and it does not address any defense to violation of probation in it. And I think that's why that addendum is important. So just want the court to know that I am in receipt of that previous evaluation that what the public defender's office requested from Dr. McDonald, and I have reviewed it. So.
And just for the record, therefore, basically, that's not the impediment. It's not a matter of that Ms. Sharpless isn't aware of the state's position, of the defendant's position. Also, is that I know from other dealings with Ms. Sharpless is she's going to defer to an expert in the field versus trying to make her own assessment of medical records and so forth.
Okay. Well, for today, I understand it's not a totally, it's not a total resolution of this matter, but I think I really think the ball's being moved down the court, and what the state just does, and it's the last thing I'm going to say, I'm not going to get into further arguments stuff. State's disagreeing with you, and the state would argue strongly against you because it's not in the report. So the state is essentially backing up what your own attorney said.
And just for the record, what is the state's offer? Does the state know what its offer would be if we resolved it today? You're paperless, so you don't have your file.
I believe that there was a guideline sentence. I believe that I don't believe I know. I had written myself a note that when we put Mr. Chartrand's case out, the state made a record that it was going to be seeking prison for the next violation, which is why we're here. So I know the state's...
We're not going to go there today. Let's see what the report says and if there's some reasonable basis for it. Okay, thank you. Yes. And we do have October 17th, just a status
Your Honor, Steve Medina with Christopher D. Call us in docket 40, 22 CF 1271, 22 CF 1273, and 22 CF 3027. Mr. Collis has in his hand, I think, a copy of an order to transport that was signed by Santa Rosa County Circuit Court to transport him over, so they just haven't come to get him yet for his court appearance. So we need to continue this. What's that court appearance in Santa Rosa is in October, is that right?
Yes, October 23rd.
Your Honor, could we get a court date over here sometime after October 23rd to hopefully get him back after he gets resentenced over there?
The next date after that one, the next miscellaneous is November 14th.
That would be good, Your Honor.
Okay. So we'll continue this to November 14th.
Thank you, Your Honor. You want me to write that down for you?
Yeah, please. Just put it up Okaloosa, okay?
Okay, yes, sir.
Thank you.
All right, thank you.
Thank you. Your Honor, William Ray Elliott is before the court, docket 4243 CF 338, and he is signing an agreement that has been worked out with the state, Your Honor, that Ms. Sharpless has previously signed. That's your copy. It's the same thing. Here. Yes, sir. I got all data. May I approach with the agreement, Your Honor?
Thank you.
Thank you. Your Honor, this was a misdemeanor resolution. I'm not sure if he has JCS or state probation on this one. I think he has. Sir, do you know, do you show state probation as covering the supervision for William Elliott?
Yes.
Okay. Your Honor, I'm going to provide probation a copy then. Thank you. Your Honor, under this agreement, 23 CF 338 VOP is going to be resolved with a violation of probation agreement that's been presented to the court, signed by all parties. He's admitting the violation. He was previously adjudicated guilty, but that was only on misdemeanors. I think count one was nolle prost, was a felony possession of controlled substance.
Under this DUI, is that was a misdemeanor?
That was adjudicated as that's a misdemeanor.
It's a misdemeanor DUI.
I think it was a second outside of 5.
Very good.
And Your Honor, there is under this agreement going to be reinstate and modify, add a special condition of enter and successfully complete Master's Touch Ministries of Pensacola 9-month program. And just for the court's awareness and probation, he represents to me that family will be able to provide him transportation to Master's Touch, which is a requirement because Master's Touch doesn't come and get you. Complete existing obligations, $100 VOP fee and 150 PD fees. I do need to note to him on the record is that, and I think probation will clarify, but basically you'll need to go check into probation 13 Kelly Avenue, Fort Walton Beach before you go to Master's Touch. So it's going to be a busy few hours for your family. Okay. That's it, Your Honor.
Very good. State?
That is the state's agreement, Your Honor.
Mr. Elliott, would you raise your right hand so you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, Your Honor.
So you heard your attorney state the terms of your plea agreement, and I see you've signed the written plea agreement, which is the same terms. And have you read this closely and gone over it with your attorney in detail?
I have, Your Honor.
Okay. And you understand that by entering into this, you're waiving the right to go to a trial. This will be a final resolution.
Yes, sir.
And you believe it will be in your best interest?
Yes, Your Honor.
Obviously, this is a good deal here. They're extending. Court will accept your plea agreement to reinstate and modify. There'll be a special condition to enter and successfully complete the Master's Touch Ministries 9-month program over in Pensacola. And then you have the financial obligations as well that have to be completed. Okay, any questions?
No, Your Honor.
Okay, good luck with everything.
Thank you, sir.
Okay.
Thank you. Yes, sir, I'm going to.
Yes.
Yes, sir. This is Ms. Okaloosa Garofalo before the court. She has recently returned back to Florida State Hospital. If we can enter or ask the court to continue her case.
What's the name?
Garofalo.
Gotcha. I'm sorry.
That's right. It's 23 CF 282 and 23 CF 433.
Correct. Okay.
If we can just have the court continue Mrs. Garofalo's cases, Dr. McDonald's going to do a follow-up eval to make sure everything's good with her mental health status.
So we need to come back on a miscellaneous docket?
Given the dockets for pre-trial on both, I would prefer miscellaneous docket.
Okay, that's fine. We'll come back on the miscellaneous. How about October 17th?
That'd be perfect, Your Honor.
Continue to October 17th at 9 a.m. No, hold on a second. Do we need to make any, I mean, it was a return from,
Yes, Your Honor.
we're not having to make a ruling on.
No, Your Honor. Not until I get Dr. McDonald's follow-up eval.
Okay, thank you.
And then I'll stipulate to the appropriate reports.
Very good.
Yeah, this is Ms. Grimm before the court in 21 CF 2189 and 22 CF 1818. This time we're going to be filing a written admission before the court. So the state's aware I do not have a copy of the score sheet. State will file a score sheet later, Your Honor.
Yes.
And I'll copy the defense on it, that way they can see it.
Very good, thank you. But it's not a downward departure?
No, Your Honor. Ms. Grimm should actually score under 22 points.
Very good. Would you please announce the terms of the plea, counsel?
Yes, Your Honor. Ms. Grimm will be admitting the violation before the court. She'll be adjudicated guilty, revoke and terminate her outstanding probation, sentenced in all counts and cases 10 months in the county jail, concurrent with credit for all time served. Standard cost of prosecution ×2, public defender fee in each case. Ms. Grimm would ask for 24 months to pay those outstanding fees before they're sent to collections.
Very good. So the 10 months is for each of the 4 counts?
Yes, Your Honor.
Okay. Ma'am, would you please raise your right hand? You swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So is the state in agreement on this?
We are.
So, Ms. Grimm, you heard your attorney state the terms of the plea agreement. There's 4 of which you put your hand down. Oh, you found it. Okay. And you're good with it?
Yes, Your Honor.
Okay. So, Ms. Grimm, you heard your attorney state the terms of the plea agreement that really the key part of it is the 10 months county jail for each of the 4 counts. They'll all be served at the same time. You will get credit for all time served. Okay? And then you'll, in addition, all of the costs and fees that are contained in here, you'll have 24 months after you're released before it goes to collections.
Yes, sir.
Okay, is that your understanding of the plea
Yes.
agreement?
Mhm.
And you understand that by entering this plea agreement, which I see you've signed the written plea agreement, you're waiving the right to go to a trial.
Yes, sir.
And you've had all your legal questions answered about this, how it affects, because there is going to be an adjudication of guilt on all these, and that has an effect. You've gone over that with your attorney?
Yes, sir.
Okay. You believe this is in your best interest to enter into this plea agreement?
Yes, sir.
Nobody threatened, of course, to get you to enter into the agreement?
No, sir.
Based upon that, the court will accept your plea. There'll be an adjudication of guilt. The court will revoke and terminate probation on all the cases and counts. You'll receive 10 months in the county jail. You will get credit for all time served. These 10 months for each of the 4 charges will be served concurrently. And then you'll have 24 months to pay fees and costs for those collections.
Okay.
Question, Madam Clerk?
This is mine.
Prince, please.
Your Honor, this is Mr. Jonathan Farrell before the court for a bond hearing.
Okay. You may proceed.
Yes, Your Honor. Mr. Farrell and I had discussed his case as far as where we were at and what's still outstanding. He had asked me to schedule a bond hearing. Mr. Farrell does have significant ties to the community. He was out on bond and 3 of the cases when he was picked up on the 4th case. That subsequently revoked the outstanding bond.
What was the 4th case?
The 4th case, Your Honor, was, I do believe, the driving while license suspended, which is a 23 CF.275. And then the state amended that information subsequently to include the DUI. The DUI is based upon, I want to say, a potential, do they do anything on that?
Blue 000 from the breathalyzer, and then they said I failed 1 marker on the DUI. What they did is I had to stop itself.
So there's no breath, the filter body test was all that's there on the DUI. He does, as I said, have significant ties to the community. He has not missed the court date as far as I know. There's no prior FTAs. Mr. Farrell simply wants an opportunity to be out of custody to fight the outstanding charges that we've got. He does have a 1-year-old son that he'd like to spend time with and see. Mr. Farrell would abide by any condition the court would feel comfortable doing, pretrial services, drug patch, scram, alcohol monitors, breath tests, weekly meetings, whatever necessary as the condition that the court would consider reinstating or setting bonds in those outstanding cases.
Steve.
Judge, to be clear, the defendant was out on bond for vehicle theft, DOCS, driving while license was suspended habitual, and trafficking amphetamine or methamphetamine 14 grams or over. And while he was out on bond, he made the decision to go drink and drive. While his license was still suspended and he had pending charges for driving habitually with a suspended license. So he's not just picking up new charges, but he's picking up the exact same charge. He's on notice. He knew he was out on bond. He knew he shouldn't be, he's not at liberty to go out into the community and commit more crimes. And he chose to do that. So he does not have my sympathies, and I believe that his bond status should remain as is.
If I may respond on that, Your Honor. The state said drink and drive, as we stated, was 000, so there was no drinking and driving on that. As far as the grand theft auto case is concerned, I know
Was he charged with DUI?
He is, Your Honor. The state of
new charge.
There's a new charge. Our intent is likely to fight the DUI depending on how the cases get resolved. So that's the least of our concerns at this point. But I do want to, the state did say he was drinking and driving, record shows it was 000. So I don't necessarily think that means he was drinking and then driving in the sense the state's trying to argue here.
Let me correct myself, Judge.
Okay.
He was not drinking and driving, he blew 000, but he was under some intoxicant at the time, which leads me to believe that it likely was drugs, which seems to jive with the other charges that he's facing. So while I understand that from a defense perspective, this is the least of his concerns, it is not the least of my concerns that he's on the streets of this community under the influence of drugs. Behind the wheel of a car.
Then, as far as a grand theft auto, Your Honor, I know Mr. Lasco wasn't present during the deposition, but the victim in that case is his mom's boyfriend, and he's already been on record and adamant, and I think he's even tried to drop the charges in that case, that he does not wish to pursue those charges. He wishes that those be dropped. That's a case that's outstanding. As far as the other cases, we've tried to work the depositions. We've had issues with witness location and our participation, so that's benefited for the case as well. I explained to Mr. Faro that this was going to be completely up to the court on considering reinstating the bond, but he had asked me to do it, and I wanted to make sure we made a good argument. And I think the court can take into consideration some of the other arguments we've made as far as inside the communities and some of the other things that is in the bond motion.
Mr. Farrow, the only thing I can say good about your cases so far is that they don't appear to have any violence and there's no guns involved.
Yes, sir.
Okay? So normally I would look at, in that situation and you know, look and see what might be reasonable. This ain't the first, this ain't the second, this is the fourth. I know one of them might be dropped. I think you need to get these things resolved and figure out where to go. So I'm not gonna reinstate the bond. I mean, it's a good argument. I mean, you've got a good argument. I'm not saying you don't have a basis for arguing it, but you know, maybe if this was the third one, I might be a little more amenable. But you know, I think you need to look at resolving all these cases and figure out what you're doing with this case.
Yes, sir.
You need to figure out if you want to be with your son. You need to take this stuff seriously and figure out how to stay clean.
Did you get this court?
He's already scheduled for the October 11th.
Okay, thank you.
Better than 96 months.
Still not service, still service.
I have plenty of guys in our position.
Very nice.
Get out. Go find another state. Your Honor, this is Mr. Griner before the court. We actually have a plea agreement to be filed in his case, if I may approach, Your Honor.
You may.
It's actually cases. He's got 4 cases before the court.
Thank you.
No objection to the score sheet either, Your Honor.
Okay.
The original sentence was a bit convoluted, so of course the VOP sentence is going to be convoluted as well, so I'll try to make it as easy as possible here. Mr. Griner will be violations before the court in 21 CF 2041, 22 CF 1349, 22 CF 1980, and 22 CF 2273. The original sentence, Mr. Griner was placed on 2 years of community control followed by 3 years of probation, concurrent between all 4 cases. He had a suspended sentence of 4 years in 21 CF 2041 and 22 CF 1349 that was concurrent with each other. And then a 4-year DOC sentence in 22 CF 1980 and 22 CF 2273 that was concurrent between the two, but consecutive for a total of 8 years DOC. After speaking with the state, we've got an agreement reached where you'll be adjudicated guilty. We're going to revoke and terminate those outstanding probation. And in 21 CF 2041 and 22 CF 1349, he'll be given the 48-month DOC suspended sentence. That'll be concurrent between both cases with credit for all time served. And then at 22 CF 1980 and 22 CF 2273, he'll be sentenced to 33.225 months DOC, no credit. The DOC 33.225 months DOC will be concurrent between the two cases, but consecutive to the 4-year suspended sentence. Essentially, Mr. Reiner is being sentenced to what a guideline sentence would be, which is 81.225 months DOC. He'd ask for 24 months to pay those outstanding costs before they're sent to collections. Standard court costs and fees in each case.
And this is not a downward departure, so.
It is not, Your Honor, and that is the state's agreement.
And just to clarify, it is in that it is a 4-year DOC sentence. Guidelines is 80 months. 33 months in the other one, guidelines is 80 months, but the idea is that he's still getting a guideline sentence without having a guideline sentence.
Correct. It will still, when you total it up, it still is the guideline sentence. It's just because they were third-degree felonies, we had to divide them up.
Very good. Okay. So, Mr. Greiner, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, and nothing but the truth, so help you God?
I do, sir.
Okay, so you heard your attorney state the terms of your plea agreement, and I see those same terms are contained in the plea and sentencing agreement, which you've signed. So my first question is, did you read this closely?
Yes, sir.
And did you go over it in detail with your attorney to make sure you had all your legal questions answered about this plea agreement?
Yes, sir.
You understand, importantly, by entering into this plea agreement, you're waiving some valuable legal rights, the right to go to a hearing, the right to force the state to prove their case. Do you understand all that? Do you believe that's in your best interest to do that?
Yes, sir.
Anybody threaten or coerce you or promise you anything to get you to enter into this plea other than what's contained in this plea agreement?
No, sir. Nobody coerced me.
And you believe that this is in your best interest to do this?
It is the best option that I can choose at this time, sir.
Okay. And there is a legal base, a factual basis for this plea?
Yes, Your Honor.
Yes, Your Honor.
Very good. Okay. Very good, Mr. Greiner. Based upon that testimony, the court, and you were previously adjudicated guilty, but based upon the plea agreement here today, the court will revoke and terminate probation on all your counts. In 21 CF 2041 and 22 CF 1349, court's sentencing you to 48 months in the Department of Corrections with credit for all time served. Okay, and these will be, the 48 months will be concurrent between both cases and all counts. Okay? In 22 CF 1980 and 22 CF 2273, the court will sentence you to 33.225 months in the Department of Corrections. This 33.225 months in the DOC will be concurrent with each other, but they'll be consecutive to the other two counts. So you've got 48 months, all served concurrent, and you've got 33.225 months, all concurrent, but they're stacked on top of one another.
Yes.
So that equals a total of 81.225 months in DOC. Of course, you will get credit for all time served. That's obviously an important consideration. Finally, the defendant would have 24 months after your release from prison before your court costs and other public defender fees, etc., are sent to collections. Okay, any questions?
Yes, sir.
You do have 30 days, even though you're entered into this plea agreement, you have 30 days to appeal this sentence. You understand?
Understood, sir.
Thank you very much.
Your Honor,
Joseph Hopkins, sorry.
this is Joseph Hopkins coming before the court in 22 CF 34. At this time, we want to let the court know that we did file a reciprocal discovery, a copy of Dr. McDonald's report. I discussed that with the state yesterday.
I have not been able to review the report. I apologize. If we pass this one, I can review it, but it might take me one moment. I apologize.
Okay.
How long? Like, are we talking 1:30 or are we talking 10 minutes?
10 minutes.
We'll bring her back, actually. Your Honor, this is going to be Mr. Aaron Jeffers before the court in 22 CF 1301. We have a plea agreement to be filed in Mr. Jeffers' case, Your Honor. It's actually going to be a plea to the court and set for a sentencing. The state did send over a score sheet, Your Honor. I will say that the score sheet that was filed at the original sentencing date in June of last year is different. There's some additional charges on this one that weren't on that one, so I'd actually like an opportunity to review that with Mr. Jeffers before we agree to that particular score sheet. The score sheet that we've got in anticipation would be right around 12.4 months DOC is the bottom end. The state score sheet, I think, is right around 14.8 as the bottom end guidelines, so about 2 months difference.
Will that affect the entering of the plea?
No, Your Honor. Mr. Jeffers and I talked, and I explained that my score sheet calculations, bottom end is 12 months. DOC states is 14 months. It is a violation of probation, so the court doesn't actually need a downward departure. The court could simply modify, which is what we are seeking. It's more of a bottom end for him. May I approach, Your Honor?
You may.
And there is no cap on incarceration or probation.
Would you please announce the plea?
Yes, Your Honor. Mr. Jeffers will be admitting the violation before the court in 22 CF 1301. He was previously adjudicated. This will be set for sentencing. There is no agreement on a cap for incarceration or probation.
State's in agreement with this?
That's correct.
Is there a straight plea agreement that has been exchanged between you all? In other words, with a set number of months?
I think the state would be seeking DOC. The question is whether it would be the 12 months or the 14 months.
So they were seeking the minimum guidelines?
Yes, Your Honor. And Mr. Jeffers and I discussed, and given the nature of the allegations, along with some of the information provided in the affidavit, I felt that pleading to the court and asking the court for a particular sentence, along with some testimony, might put the court in a better position to consider a reinstatement versus an incarcerated sentence.
Okay. Mr. Jeffries, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
Okay, so I see you've signed the plea and sentencing agreement, and I'm assuming, and I'm asking you, have you gone over it in detail with your attorney?
Yes.
And you understand the maximum sentence that the court could give you on this case, do you?
Yes, sir.
How much?
Seems like 5 years.
Plus one.
I'm sorry?
plus one.
The
6
county-
total.
the county jail. Yes, sir.
Okay. You aware of that?
I am now. Yes,
You
sir.
are now? Okay. It's not a big change, but it is a change. The thing that I want to explain is that, you know, a lot of people, quite frankly, they see this number, which are minimum guidelines, and they go, you know, these are guidelines. This what the Court of Senate says. They don't remember. They don't key in on that first word. Minimum guidelines. That's the floor essentially. Now I can go below it. I can do that. But those are the floor. But it also can be above that.
Yes, sir.
I just want to make sure you understand it. You know,
I do.
I'm occasionally, I sentence, they plea to the bench, and like, and they get a sentence above the guidelines. They go, they're like surprised that the court would consider giving above guidelines. Like that's what the sentence should be. You understand that? You can go above that.
I'm sorry?
You understand the court can go above?
Yes, sir, I do.
The 12 or the 14, whatever the minimum guidelines are when we go to a final hearing. You understand that?
I do.
You believe that's in your best interest to do this?
I believe so.
Why?
Because I'm hoping the court will take a little mercy on me and reinstate my probation. I was kind of given not so fair of a chance to complete everything. I was homeless and didn't have a means of getting back and forth to work and stuff to get money to pay my probationary fees and all that. So, you know, just asking for another chance. I've got a place to stay now, good job.
Okay. I just want to make sure you're going into this with your eyes open.
Yes, sir.
Okay. And know that there really isn't anything that's certain on this.
I understand that.
Very good. Based upon that, the court will accept your plea.
Okay. I will let them
And
know.
there's a previous adjudication of guilt, and the defense is pleading to the court with no cap on incarceration or probation. The court could mix and match however they see fit with the upper maximum of the 6 years. Okay. You understand any questions?
We'll
Coordinate with Miss Eileen. How long do you anticipate?
I would anticipate
An hour?
if I wouldn't say more than 30 minutes, and that would be pushing it, I think, Your Honor.
Okay. We'll just let Miss Eileen know that one.
Yes, Your Honor.
We'll get it on as soon as we can.
Okay. I see it. Get some information. Oh, okay. Start putting that information on top of your arm. Yes.
Cody Wilcox.
Yes, I am showing that he was sentenced on September 12th.
Who's handling Robert Daniels?
That was my case.
23 CF 565 John Madden's case?
Yes, Your Honor. If you'll recall, when Mr. Madden was in court, the last court hearing, we resolved Mr. Daniels'
Okay,
case.
somehow it ended up back on our
She didn't get it resulted in time. With it being on September 12th and today being the 19th, she didn't get it resulted.
So we're good? Everything's good?
Yes, I checked both cases and
Okay.
they showed.
I just wanted to
they
make
showed
sure we
it's
didn't need
closed.
to do anything today.
Yes.
Okay, sounds good. I'm sorry, Mr. Gates?
Yes, Your Honor, this is going to be Cody Wilcox before the court in 19 CF 1952. I'm waiting for the state to sign our plea. Your Honor, this is, Mr. Wilcox is going to be admitting the violations in paragraph 3 and 5 of the affidavit. and asked that his case be set for sentencing. I explained to the state that that was our intent, so I don't know what the state intends to do. If the state wants a hearing on the other counts, or we just want to go right to sentencing.
The state would be fine going straight to sentencing.
Not today, not straight to sentencing, Your Honor, but set a sentencing date on the counts that we've admitted to. My anticipation is this would be a little bit longer of a hearing, mainly because I'm anticipating the state probably having some witnesses. We anticipate maybe Mr. Wilcox or his mother.
Okay.
May I approach, Your Honor?
You may.
The score sheet here, again, it's one we'll have to figure out, Your Honor. It's either going to be 28.4, which is what I think, or 28.2, which is what I think it should be, or 34.2 points. So underneath guidelines.
Okay. The jury's right answer. You swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God.
Yes, Your Honor.
Okay, so I see you signed the plea and sentencing agreement. Have you read it closely and gone over it in detail with your attorney?
Yes, sir. I have.
All your legal questions answered?
Yes.
And the important thing about this is you're pleading to this, you're basically admitting some portion of the VOP. I know not all that's a little bit unique, but you're basically admitting the VOP.
Yes.
And, but we're not, you haven't come to a specific plea agreement with regards to what the sentencing is. Do you understand that?
Yes.
And while the guidelines, people often are confused about guidelines. The guidelines will say what the minimum is to the court. But the court can sentence you up to what in these cases? You know that? You understand my question?
Yes, I read there's no cap or limit.
And what is the maximum sentence on the 2 counts? You know?
I think the guidelines say 5 years.
Well, those aren't the guidelines. Those are actually the maximum. On the felony, it's 5 years, and the misdemeanor, it's 1 year. So it's a total of 6 years.
Okay.
I want to make sure you're aware of that.
Yes.
I could sentence you to 6 years.
Yes, I understand that.
Okay? Now, the state's not offering you, they're offering, what are you offering, a specific guidelines or just nothing?
Judge, at this time, I think the court will recall that this is the violation of probation that was triggered by the defendant getting a DUI in another state, hitting a motorcyclist, which ultimately resulted in the motorcyclist losing his legs and then dying. So the long answer, that's a long answer, Judge, but I would say right now I'm not making an offer, and I will make that determination after the sentencing hearing.
Okay.
Thank you.
And that's why if the court looks, we specifically admitted violations 3 and 5 and not that new charge in Alabama.
Sure. Okay. Very good. So, you understand that by entering into this, this will be a final resolution of the first part of it. And
Yes.
then you can't back up if you don't like the sentence.
Yes, I understand.
That?
Yes, I do.
You believe this is in your best interest?
I do, yes.
Okay. Court will accept your plea, and it will be an admission on certain of the counts, and there'll be, basically a plea to the bench, no cap on incarceration or probation.
Judge, I think I might have a question here. So, you admit to which ones?
Failure to pay in the DUI school.
Is it too late for the state to request a hearing on the other counts, which was the new law violation?
Thank you. We can, if the court, that's where it's happened.
So it seemed to me that the court would have to have that hearing before the sentencing.
I would think so, Judge.
Right?
And that's where the state and I've had that issue, is that the new law violation has been dismissed in Alabama with the intent to file on additional charges, which we were hoping would have been done by now, but hasn't. And so that's kind of the position that we're in. The state wants to pursue forward the can on charges that were dismissed from out of state.
Judge, I would say that first off, to Mr. Gates's point, the new law violation was dismissed out of the state. That was because they were planning on indicting this man and proceeding on manslaughter charge, is my understanding. So from the state's perspective, we do believe that there still is a violation that's viable and we can proceed to a hearing on.
even on the criminal charge up in,
That's correct.
well, do you think you can? I mean, we'll do it.
And that's where I've had that conversation with offices. I explained that even if we do admit the state still could have the hearing, there's a lot of pieces the state would have to get to that. In all honesty, I think the state and I were hoping, we were told at the end of August there would be an indictment. It never came. And instead of waiting around to try and get it resolved, Mr. Wilcox and I talked, and we spoke specifically and said, let's try to get it resolved, set it for sentencing, and then go from there. I understand the state's position as far as wanting to bring evidence in, but I'll save it for arguing, Your Honor. I'm going to get into an area I don't want to speak on really right now.
Yeah, but there's not a legal basis to oppose going to a hearing on the two counts that were not admitted before going to sentencing. That seems like the appropriate procedure to go forward. If not,
it just seems to me like a waste of time because the state still could present any and all evidence that they wanted to sentencing. And if he's indicted, my anticipation is that an amended affidavit is going to come through with an amended allegation for manslaughter at that point. Those are all moving pieces out there.
Judge, my request would be that we set a date for that hearing, carve out some time for a sentencing afterwards, and in the meantime, I'll get to work. And if for some reason we don't need that evidentiary hearing, I'll advise the court.
It just
well, I understand why they want the evidentiary hearing because they want to be able to consider that, and they did it. Your reaction to them is exactly why. You'd rather not bring the new law charge because.
But it's already part of the affidavit, Your Honor. It's already there. And at sentencing, I would assume, and I'd have to do the research, but I would assume it's likely the state can at the very least approach on that issue as far as sentencing is concerned, because that's part of what's out there. My issue again is we're having a hearing for the court to determine whether.
There's a reason why you're opposing. You're not wanting them to go forward with their.
No, Your Honor.
Make some argument that.
I'm opposing him entering a plea, admitting charges that were dismissed. That's the key. Those charges were dismissed, so we're not going to admit to that.
Right. I get that.
And so having a hearing for the court to determine whether he's in substantial and willful violation when he's already admitted that he's in substantial and willful violation seems like a colossal waste of time to me. I get the state saying, well, we want to improve, we want to have a hearing, but that's what we can do at the sentencing. The court can consider that as part of the sentencing.
If the court can consider and you can basically bring everything you would bring in the thing, why don't we just do it at the sentence?
I would be fine with that, Judge. My main concern was not being able to talk about the new law violation at the sentencing.
I kind of read the same thing, that it appeared that you were, and that's when he asked for, when it appeared that you were going to be making those arguments. And, oh, no, we're not admitting that. That can't come in.
No, Your Honor. This is where I would get the state to make sure, but because there was an arrest and charge out there, that still can be considered, even ultimately have a hearing on it. We've been there before.
Right.
And so I would, at sentencing, given the arrest and all that out there.
And hopefully by that time there'll be
we'll have an answer on that other charge.
Anyway. I mean, if there is going to be one, hopefully they can move on it.
Yes.
Unfortunately, the wheels of justice often move slow.
And just so the court's clear, I did explain to Mr. Wilcox that my expectation was that the state was going to bring in witnesses and testimony about that. So he knew that was the potential prior to entering the plea, just so the record's clear. The court's asked. We had that conversation and said it's my anticipation. Sentencing, the state's probably going to bring in a bunch of people and make it about how bad Mr. Wilcox is and how little the person he is at that sentencing, including those charges over there.
Okay. Well, then let's go ahead and just bring it all in, and you guys can, whatever amount of time you all feel is necessary, and it may take a little longer. So you understand, Mr. Wilcox, I'm going to double back. That, they're going to raise all these issues when they
I understand.
Make their sentencing, and they may be seeking, probably will be seeking in excess of guidelines. minimum guidelines. You understand that?
Yes.
And you understand they can do that, and the court can do up to 6 years.
Yes, I understand.
Okay, either a incarcerative sentence or probation or some combination thereof.
Yes, I understand.
Okay. Okay, very good. So the court, like I said, will accept your plea, and we'll go to a sentencing on this at the discretion of the court.
Yes, sir.
Thank you.
Thank you.
Do we have a date for that? I'm sorry.
Oh, we got it coordinated. Thank you. Sorry.
Your Honor, Steve Medina with Mr. Matthew A. Phillips in docket 43, case 20 CF 279. Mr. Phillips is signing an agreement to resolve his violation of probation. The state's already signed it, Your Honor. And the state's gone paperless, and I think that my file may have the right score sheet. I just need to confirm that, Your Honor. This is going to be resolving with a 12.1 DOC sentence with credit for all time served, and I just want to make sure that we've got it. Your Honor, I'm approaching with the state score sheet as well as the signed agreement. Yeah, it's 36. May I approach, Your Honor? I provided a digital copy to state probation. I hope that it's been able to open that.
And the defense is okay with the score sheet?
Yes, Your Honor. And just opening up the agreement on my phone, Your Honor, so I can narrate the terms. The defendant, under the violation of probation agreement, will be admitting the violation. It's adjudication of guilt. I think he was previously adjudicated. Is that correct? And it was on lesser included offenses on the felonies. They were knocked down to still a felony, but a third-degree felony previously with a level 1, I believe. There's adjudication of guilt, as I stated, 12.1 months, concurrent DOC on felonies with credit for all time served, revoke and terminate probation, $100 VOP, 150 public defender fees, monetary obligations to collections 12 months after release, time served on misdemeanors.
State.
That's the state's agreement, Your Honor.
Mr. Phillips, would you raise your right hand, sir? You swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
It was a little tricky, and by way of explanation, I see you've signed the plea and sentencing agreement that states the terms of that.
Yes.
Have you gone over it with your attorney in detail?
Yes, sir.
So the key thing is, you got 2 felonies and 2 misdemeanors, right?
Mm-hmm.
The 2 felonies, you're being sentenced to 12.1 months DOC. Both of them. Run concurrent, so run at the same time. And then the 2 misdemeanors, credit for time served, those will go away. Okay? That's the basic, plus all the fees and costs that'll go to collections. Did I say that wrong?
No, you said it right, Your Honor. I just wanted to put something on the record I failed to note. May I?
Go again.
The state's recommendation had been Barstebed Keaton. I've consulted with Mr. Phillips about that, as did Charlie Russell, my supervisor, and Mr. Phillips did not want to do Phoenix House or Keaton. And so basically he understands that even though he doesn't score a minimum guidelines prison sentence, the state's position was 12.1 DOC if he didn't want to do the Keaton. So that's what he's decided is his best interest. I hope, and I've discussed with him, that he will seek treatment on his own when he gets out.
And hopefully, while you're in.
Your Honor, could-
We have some programs that are in.
Could the court-
At the end of the day, you're gonna have to get out and, you know,
Yes.
be back on the street. You know, you understand what the gig is now, and hopefully you can get clean. We want you to be clean.
Your Honor, could the court ask that he, the DOC, allow him to go to a DOC facility that would be able to provide drug treatment?
Yes. The minutes would reflect that.
Yes.
Okay, so 12.1 months, both the felonies, credit for time served on the others. And so you understand that by entering in, this will be a final resolution of your case?
Yes.
You believe this is in your best interest here today?
Yes, sir.
Okay, do you have any questions concerning the plea or anything that's involved with?
No, sir.
Good luck.
Thank you.
And you will get credit for all time served.
Yes. Thank you.
Thank you, Your Honor.
Your Honor, this is Joseph Hopkins for the court. It's 22 CF 34. It's passed for the state to get an opportunity to review the eval.
The state's had the opportunity to review the eval, and the state will be stipulating to it.
Yes, Your Honor, and I'll pause and let the court.
Hold on, gentlemen. There you go. Go ahead, I'm sorry.
Yes, Your Honor. Based upon that stipulation, the defense has an order adjudicating the defendant competent to proceed and placement for a state hospital, if I may approach, Your Honor.
You may.
And for the record, I did verify we had the right doctor on this one.
Okay. Okay, based upon the report and the stipulation of the state, the court will adjudicate the defendant incompetent to proceed and commit to the, basically the state hospital, but through the Department of Children and Family.
Thank you.
Good luck, sir. Good luck,
We'll bring Mr. Hart back at 1:30.
I've got just a couple of cases that, Mr. Gates, a Sean Florence and a Donald Frazier.
Your Honor, Mr. Florence was in court last week on a Nelson hearing, or Feretta hearing.
Yeah.
And at that time, we entered a denial on the VOP and had everything scheduled for October the 9th.
Okay, very good. And then what about Donald Frazier?
Your Honor, I don't see Mr. Frazier in the courtroom. I will tell the court that he is homeless and depends on the bribe from strangers. He, as typically, will contact my office later and say that he was trying to get here and just couldn't get here in time. If we could wait till this afternoon to see if he comes.
Sure. I don't have a problem with that.
Thank you, Your Honor.
Very good. I think that's.
German?
Giovanni German, we filed a notice of cancellation and that yesterday, Your Honor.
Okay.
Mr. German was released on
Got
bond.
another file, another court date?
Yeah, he's currently scheduled for October the 9th.
Yes, sir.
It was a bond hearing. He bonded out, which mooted the bond motion.
Certainly. Living